So our next panel is entitled, Where Do We Go From Here? And we've asked 3 of the top juvenile justice attorneys in the nation to assess juvenile justice legal reforms and their implementation over the past decade, those successful and those falling short, and strategies moving forward. So Marsha Levick, who's Deputy Director and Chief Counsel of the Juvenile Law Center, will be our presenter moderator. Let me tell you just very briefly about Marsha and her astounding accomplishments. She's co-founder and the Deputy Director and Chief Counsel of the Juvenile Law Center, which is America's first public interest law firm for children. She's participated in numerous cases before the Supreme Court, as well as federal and state courts nationwide. Notable cases include Roper versus Simmons, Graham versus Florida, Miller versus Alabama, and Montgomery versus Louisiana. And so in her bio, you'll know the significance. You'll find out the significance of these cases and what Marsha and other juvenile justice lawyers have been able to accomplish. So they're going to be kind of piggybacking on what Michael just did, but they're going to be focusing on the law. Marsha?
Thanks so much. So good morning. First of all, thank you to Steve and Joe for putting this conference together, for inviting us to be a part of this conversation. I have participated in other days like this with media fellows and have always really welcomed the opportunity to have this exchange with individuals whom I consider to be messengers. Not our personal messengers. We know that you're all unbiased, but you are messengers of the work that is being done in this field. I obviously, of course, also want to recognize Carol and recognize Diane, 2 of our very key foundation and funding partners in the advocacy work that all 3 of our organizations have been involved in. We have a great panel here this morning because I have 2 colleagues to my left and my right who are both terrific experts and advocates in the field of both youth justice and the child welfare system. To my right is Kim Dvorchak, who is currently the Executive Director of the National Association of Counsel for Children. And to my left is Michael Harris, who is currently the Senior Legal Director at the National Center for Youth Law, has also worked at the Burns Institute. Both of them, and I can say this because I know I'm a lot older than both of them have long histories in doing this work, and that's a good thing because they bring a lot of wisdom, a lot of experience, and a lot of perspective and insight into the issues that we're going to talk about. I want to just piggyback, starting out on the information and discussion that we just had from Michael, because I don't want to repeat what he said. I want to pick up on some themes. One is the importance of recognizing that the field of youth justice today is dynamic. It is not static. And I think that while he gave you the very brief, arguably 30-second history of the system, in thinking about what transpired between the late 1980s and 90s, where we went into a very punitive mode, to 2018, where we are increasingly open to focusing on the positive, in a respect what Carol said at the beginning of her remarks, in thinking about why do we measure what kids don't do, why don't we measure what kids do, and that willingness and that embracing of thinking about how we can help kids, how we can promote kids, how we can engage them productively is really at the forefront of the conversation that we're having today. And those changes are allowing us, as I said, to view the system as dynamic. It is open to change. I would add to something that Michael said. He talked about the 3 criteria that he thought were critical to creating this climate for change. I'm going to add a 4th, and that's low crime rates. And I frankly would argue that that's actually the most important, because the reality is that in the absence of policymakers, legislators, judges, prosecutors. We on the defense side are always advocating for better outcomes. But frankly, for that part of the system, for those participants in the system, if the crime rates were high, as they were in the late 80s and early 90s, there's no space for progressive advocacy and progressive action to be taken because public safety trumps all. But the fact of the matter is that since 1994, crime rates have dropped. They've dropped consistently. If there have been upticks, I literally saw something come in on my cell phone while I was sitting here listening to Michael's remarks that apparently the homicide rate in Philadelphia right now is the highest it's been in 6 years. That can sound like a scary number. Frankly, I kind of closed my phone and I was a little bit of like whatever, not because I think it doesn't matter, but because what I also know is that it just means it's just kind of flat. It's not really rising in the false narrative that has been created at times from D.C. about this rising crime rate that's going on in the country is a false narrative. So I'm not freaked out by reading that number. The other couple of points that I want to make in setting the table in a way for the comments that Michael and Kim will offer you is to first of all fill in a little bit about what a difference the developmental research has made. So there's no question but that when we talk about youth justice today, everything is framed in the context of the developmental framework. It is that kids are different, and the reason why kids are different is obvious to every one of you sitting in the room, but fortunately, we also have a scientific foundation that establishes in very concrete, importantly scientific, researchy ways that give us a vocabulary to talk about kids as being developmentally different from adults in ways that reduce their blameworthiness and their culpability. And that means that we now have the room, the freedom, the leeway to punish them less. And that is critically important to how we think about kids in the justice system today. The traction for that research came from the most important place in the country, although it feels funny to be talking about that as the most important place in the country right now, given what day we are on, but I'm talking about the U.S. Supreme Court. Be that as it may. Between 2005 and 2016, the U.S. Supreme Court issued 5, every one of them groundbreaking landmark decisions that literally altered the sentencing face of our justice system by eliminating the death penalty for juveniles in 2005, by prohibiting any life without parole sentence in 2010 for juveniles who had been convicted of non-homicide crimes, by eliminating mandatory life without parole sentences for any juvenile convicted of homicide, and most recently in 2016, by mandating that though that decision prohibiting mandatory life without parole needed to be applied retroactively, meaning that the couple of 2,000 individuals serving life without parole sentences across 28 jurisdictions in the United States were all entitled to resentencing hearings. That process is underway today. In some jurisdictions, it began in 2012 and 13 after the Supreme Court decision in Miller. In the 3 largest states, including mine, Pennsylvania, Michigan, and Louisiana, whose courts didn't think that Miller would be a retroactive decision, we only began that work in 2016, although I will tell you in Pennsylvania, the state that has the largest number of juvenile lifers in the country and in the world, 525, we are racing through our resentencings. That's a good thing, not racing through in a sloppy way. We have over 100 individuals who have been released back into their communities. This is a good thing, and I think that, surprisingly to me, that actually I think our advocates and our community in the state of Pennsylvania is actually doing a very good job at resentencing these individuals. So those Supreme Court cases would, as I said, each one of them groundbreaking, have really changed how we talk about youth in the justice system. Those cases focused on sentencing. But there was a 5th case that the court decided in 2011 called JDB versus North Carolina, where the court also utilized this research and also upended a 50-year-old decision, Miranda versus Arizona. Everybody knows what Miranda is. The traditional application of Miranda for kids who were subjected to law enforcement interrogation was no different than adults. So the question that cops have to ask is, do I think that this individual knows that they could terminate or walk out of this interrogation room? If I think they can't, then I do need to give them the iconic Miranda warnings. Well, it took 50 years for the Supreme Court to recognize that 12, 13, 14, 15, 16-year-old kids probably wouldn't feel the same freedom to walk out of the interrogation room. Of course, I've always said I'm not sure I would feel so free to walk out of a closed-door interrogation room with officers with guns on their hips, but I'm pretty sure that my daughters, when they were teenagers, would not have even thought that they could do that. And so in that case, the Supreme Court took that research that up to that point had really been focusing on kids in the adult criminal justice system. What Michael talked about this morning about kids who, as a result of the hysteria created in the late 80s and early 90s, something that Professor Buffy Scott refers to as a moral panic, that pushed so many kids into the adult system. It turns out that in JDB, the court took that same research and said, this isn't just about kids being treated like adults who we need to bring back to the kid level. This is also about kids in the juvenile justice system whom we also need to treat like children. And we can't automatically, without thinking, take adult criminal justice policies and practices, court decisions like Miranda, and just apply them to kids as if they're all the same, because they're not. So those are groundbreaking developments that were completely dependent upon the research that came out of the MacArthur Research Network and colleagues, some of them in this room, who have continued to do the on-the-ground implementation and application of that research, but that also would not have the staying power that they now have because of the U.S. Supreme Court decisions. So that's an important point to keep in mind. The last point that I'll make before turning over to Kim and Michael to talk about where are we going from here, and they're each going to talk about some specific issues that they've had direct involvement with, is also to just, in a way, acknowledge and impress upon you that when I say that the system, that the conversation around youth justice is dynamic and not static, it is so dynamic that the traditional assumptions that we've had about youth in this country, which is at the age of majority, is at 18, right? 18 or 21. You get to do all sorts of things at those magic ages that you can't do when you're below 18. You need parental permission to do many of those things, can't serve on juries, can't vote, etc. Well, it turns out that the research, again, going back to the research, both the psychological, behavioral research, and the neuroscience that talks about how key regions of the brain are still developing for adolescents and young adults into their early 20s, that research is now pushing both the advocacy community, the research community, and stakeholders in the justice system to think about and possibly re-examine boundaries that we have long considered sacred. So those boundaries are, number one, 18. So anybody who is below the age of 18 is in the youth justice system unless they're prosecuted as an adult, and we'll hear more about that from California, and anyone over 18 is automatically going to be sentenced as an adult. Well, it turns out that's a fluid line. And while we have not seen a dramatic undoing of that boundary, we do know that we have a handful, and I mean literally a handful. It's like not exaggerating and not hyperbolic or underestimating, a handful of judges in both federal and state courts around the country that are pushing that line up and taking the Supreme Court decisions that struck extreme sentencing, life without parole, death penalty for kids under 18, pushing that boundary up to 21, 18, 19, in some cases where that happened to be the age of the petitioner before the court, to say that you have to apply those same scientific principles of reduced culpability to this population as well. That could be huge. It could be a blip. But it's certainly something that we're keeping our eyes on. The other piece of that fluid border, that fluid boundary, which I know Michael will talk about, is the lower age of responsibility. So across the country, juvenile justice system is 100-plus years old. In some states, there's no lower age at which kids can be pulled into the juvenile justice system. In my state, in Pennsylvania, it's 10. In many states around the country, it might be 7 or 8. I think 10 is probably closer to the average. There is movement to raise that age to 12. And that's quite significant because that means that individuals below the age of 12 simply can't be prosecuted, can't be charged with juvenile delinquency in the juvenile justice system, and therefore are spared the exposure to all of the many detrimental and harmful things that happen to kids when they come into that system. So I'm going to stop there and just sort of, as I said, set the table for some of the things that we're thinking about as advocates, and I'm going to turn it over to Michael.
Good morning, everyone. I have to say that some of my thunder was stolen by the other Michael who came before me. We didn't collaborate ahead of time on what we were going to speak on, so there is some overlap. So, which is good, because now I can go into a little more depth. So I'm going to start off talking about that same period of time that he identified as being so crucial in understanding how juvenile justice works in this country. So I'm going to focus on the 1990s. But just to set the table, I want to take you back to the very beginning of the creation of juvenile courts in this country, which he mentioned in Cook County. And the idea then was we should have courts that treat young people, treat children differently than the way in which adults are treated. That was a fundamental idea. Prior to that point in time, kids were treated like adults. So if you broke the law prior to 1899, you were, had to endure the consequences just like an adult did. So that was a major transformation, and as you know, all the states picked that up and ran with it and adopted their own juvenile courts. The other piece that's really important for your understanding is the fundamental underlying principle was that these young people needed to be rehabilitated, in contrast to the adult system where punishment was the operating assumption. And for many, many years, almost 100 years, that was the overarching principle in the juvenile justice system. These are young people, they've strayed off the course, but they need to be given whatever help they can be given to be rehabilitated and get back on the straight and narrow and become productive citizens. So now we're going to fast forward to the period that Michael talked about, the 1990s, and he touched on the fact that there was rising crime. That was really important. There were 7 years in a row where juvenile crime, serious juvenile crime, increased. He also touched on the fact that the media was covering that crime in a much more aggressive and highly visible way. What he left out, though, I think is very important, which was there was a few seminal cases that were transformative, and those cases were very racialized. And that component cannot be understated, how race is used as a way of changing policy in the juvenile justice system. And this is also a reoccurring theme in that very heinous crimes are the predicate for harsher policy changes in the juvenile justice system. We've seen this time after time, particularly with sex crimes and other things. But I'll save that for Q&A. So the particular one I want to bring to your attention that happened in the 90s was the Central Park jogger case. This was a case where 5 young people were arrested, black and brown boys in their teens, were arrested within days of a Wall Street banker being brutally attacked and raped in Central Park. I cannot overstate to you how much coverage that case got. Unbelievable coverage. Every national media outlet covered that thing for weeks, for months. Okay, I'm going to digress. Please forgive me. At the time, okay, so you know that just last week, maybe it was this week, the President of the United States said it's so important that we respect the presumption of innocence, but that's in the context of his boy, Brett Kavanaugh, being nominated to the Supreme Court. So just hold that in your mind for a second, and now let's go back to the 1990s. The Central Park joggers case was really notorious, and these 5 boys were arrested, interrogated nonstop for hours and hours and hours until they were forced to confess. Wrongfully, it turned out someone else had done it. And Trump, at that time, just an ordinary, regular New York person, said in a full-page New York Times advertisement, so he paid money to put this out there, he said all 5 of them should be subjected to the death penalty. So that just gives you a sense of, one, how this had become racialized, because this is just black and brown boys, and I guarantee you if those were white boys, he would not have said that. And number two, because it was getting so much media coverage, this is an area where ordinary people who have nothing to do with the justice system felt comfortable jumping in and weighing in on the question. So you already heard about DiLulio and Fox as these academics who put out these theories, these predictions, based on what he talked about, the increasing crime over those 7 years. But also what they focused on that Michael didn't mention was the size of the cohort that was coming into teenage years. What they identified was that cohort was much larger in size than the one that preceded it. And it also contained more youth of color. So this was a very racialized prediction that they made. And they said so explicitly. They made reference to black and brown boys being remorseless and having brutal intentions. And if states don't get in front of it and take steps now before they get to the age where they are doing all these terrible things, we will not be able to control it. They were very persuasive. Over 45 states changed their laws to allow easier prosecution of children in adult courts. 45. And that happened in one of three ways or multiples of these three things. One was they expanded the crimes that made you eligible for prosecution in adult court. They expanded the age range that made you eligible for prosecution in adult court, and, which I'm going to talk about a little more specifically in our experience in California, they introduced this idea where prosecutors on their own initiative could file cases in adult court against young people without having to first file in juvenile court and file a motion to transfer that case to adult court in front of a judge. So then this power resides solely in the hands of prosecutors. So that's a really amazing departure from the pre-existing practice. So I want to talk a little bit about what we experienced in California in that regard. So in 2000, so this is 5 years after DiLulio and Fox came out with their prediction, and 5 years after crime rates had started to go down, the prosecutors, law enforcement, and conservatives in California put a ballot measure to the people saying we need to change our laws because they're too weak, they're too soft, they're too easy to get around for young people who are committing these terrible crimes. Again, this was racialized. So the name of the initiative was the Gang Response, Gang Prevention, and Juvenile Criminal Prevention Act, right? And so automatically, we know when the term gang is used, people immediately start thinking black and brown kids. And when they advertised to support this initiative, all their advertising was focusing on gang activity, and they were showing pictures of black and brown kids. So it was a very racialized campaign. They won, and this initiative did several things. So they had the trifecta. They went for all three of the things I just mentioned. They gave prosecutors the power to take cases directly to adult court on their own initiative without first having to go to juvenile court. They expanded the age range of young people eligible to be prosecuted in adult court. And then third, they also expanded the list of crimes that could be the basis for prosecution in adult court. We went from less than a handful to over 30 crimes that were eligible for adult prosecution in California. And so what we saw as a result of this initiative, once it passed, we challenged it in the court, so there was 3 years of litigation around it, but once it was upheld, from 2003 to 2016, we've gone back and looked at the data. And what we've learned from that is a couple of things. One, prosecutors began to use this much more so even when crime rates were going down. So the way we equalize that and look at it is we have this rate of serious juvenile felony offense. So that arrest rate was going down in California, where the use of direct file was going up over this 13-year period. The other thing is it was very racialized. So if you were Latinx, you were 3 times more likely to be filed on by direct file. If you were black, you were over 10 times more likely to be filed on in adult court by direct file in California. The way it was sold to the public and the way it actually played out was very racialized, and that's not an accident. And I'll talk more about that in a minute. So let me just tell you the good part of the story. There is a good part. So the advocates in California got together and decided to try to do something about this, partially as a result of the success in other states. I'm looking at Kim. And so we wanted to put a ballot measure on the ballot to overturn Prop 21. We submitted our language, and the governor actually liked it, Governor Brown, and so he agreed to give us some money to help us with the campaign, and he tweaked our language, and we were successful in getting that passed. And so we were able to take back the power for direct file from prosecutors. They no longer can do that in California. We also reset the table, so even in transfer hearings, when they ask to move young people to adult court through the juvenile court system, there's a fair, balanced way of evaluating that. And so we changed the rules for that as well. So we had a very big success. So should I talk about the other stuff recently, or wait?
I think you should talk about the two most recent bills.
Okay, so we are very lucky in California. Just this past weekend, advocates that we've been part of, a coalition, have successfully passed and gotten signed. There's actually three big ones. One, Marsha made reference to earlier, is we have set a new floor for juvenile court jurisdiction. So we passed a bill that said children under the age of 12 can no longer be prosecuted in juvenile court. And so what that means is those young people who are alleged to have committed crimes in that age range will now have to be treated by child welfare or other places, mental health, behavioral health, or given services at home from community-based organizations. So that's one big win. The second big win is a further rollback on the Prop 21. We eliminated two of the ages in which young people could be prosecuted in adult court. So now, instead of having 14 through 17, it's now only 16 and 17. So 14 and 15-year-olds are no longer eligible for transfer to the adult court. So that's a big win.
Huge.
That's really big. That's really big. And don't tell anybody, but we're coming back for those other two before too long. And the last one is this thing that's a little bit arcane. It's called the felony murder rule. Felony murder rule, in a nutshell, basically says anybody who participates in any way in a felony that results in someone dying, whether by heart attack, by accident, or any way, is guilty of first-degree murder, which on its face is like, no, that can't be right? But yes, that's how it is. And so what we found over the last several years is there were a lot of young people who were getting life sentences as a result of the felony murder rule for criminal behavior that was like being a lookout or just sitting in a car while other people they were friends with engaged in a burglary and someone died in that process. So we reformed that, so now unless you're an actual participant intending someone to die, the felony murder rule does not apply to you as a juvenile. That's a big one too. Okay, so I'm gonna stop there. I've been talking for so long and pass the mic.
Before I pass it on to Kim, I want to make one point here. So it should be clear to you now that it's impossible to talk about the youth justice system and, frankly, the criminal justice system without confronting race. And we're talking about racism, the racialization of our justice system, and the racial disparities in that system. And you heard Michael Pierre talk about things that DOJ had done well, that OJP had done well prior to or throughout the 80s and 90s in terms of funding research and some of the research that was instrumental in the changes that we're talking about. However, within the last month, the administrator of the Office of Juvenile Justice and Delinquency Prevention made a decision to cease collecting data on racial disparities in the justice system. So when I say that what happened in California this weekend was huge, this is also a hugely disappointing move because the reality is that what we measure is what we work on. And if we're no longer collecting data on racial disparities in the justice system, we are not attempting to solve that problem. And the justification for not collecting that data was because of a shift to public safety. We don't have a public safety crisis in this country. And on that, Kim.
Let me take care of that for you.
Please.
Good morning. Thank you for inviting me to this event today. I've sent my current contact information to the presenters of this conference, and hopefully all of you can get my bios and my accurate email address moving forward. But I'm very thrilled to be here and want to talk a little bit about what I've experienced both on the juvenile justice side of the equation and the child welfare side of the equation. I'm from the state of Colorado, which tends to fancy itself a pretty progressive state, a purple state. But we were one of the very early states to expand prosecution of youth as adults. And it had all of the same ingredients that was discussed earlier: high media coverage, race-based incidents that received a lot of media coverage, public outcry, special legislative session, and Colorado dramatically expanded the prosecution of youth as adults, and at the same time created a new prison for youth as adults, almost as a cover to say, well, we're not really going to send them to adult prison. We're going to make an adult youth prison for these youthful offenders. And that went on until about 2005, 2007, and then unfortunately there were a couple of suicides. There were two men over a period of, two young men, 17 years old, over a period of 8 months, that committed suicide in adult jails. They were in solitary confinement for months on end. They were hopeless, and they were a wake-up cry, a wake-up call, and a cry for action to all of us, because there were initial challenges to the direct file law when it went into place in the 1990s, but over time there was sort of complacency, and it was just the way things was, and it was business as usual, and a prosecutor could decide you're going to be in adult court, and then a prosecutor would decide you're going to be in adult jail, and there was nothing you could do about it, so you just went along and took a plea bargain, and your kid went off to the youthful offender system, and that was business as usual for a really long time, until these two young men committed suicide. At that time, I was part of a growing juvenile defense community, and we decided we can't stomach this anymore. We are going to try to change the laws, and we're going to try to change practice in the courtroom. So we started filing motions, we started objecting to the jailing of these kids, we started doing legislative advocacy, and over time we were able to start with some incremental reforms and move up to a real landmark piece of legislation, which I do think helped lay the ground for California in 2012. And that law gave every child who was charged as an adult the right to what's called a reverse transfer hearing. That meant that if the prosecutor filed the case in the adult court at the first place, every child, including those accused of first-degree murder, could petition the court to go back to the juvenile justice system. And they would have the right to counsel, they would have the right to a hearing, and they would have the right to present evidence. The law also said that every child prosecuted as an adult had to be kept in a juvenile detention facility. So they could no longer be automatically sent to an adult jail upon charging. There was a new provision instigated that said that if the prosecutor wanted to move the child, they had to file the motion to move the child out of the detention facility into the adult jail. The law also eliminated mandatory minimum sentencing for crimes of violence for youth who were convicted in the adult system, and narrowed both the age and the offenses that could be charged as adults. This had an incredible effect. In 5 years, working from incremental change to the first year of implementation, the direct file rate in Colorado dropped by 78%. The jailing of children dropped by 99%. There have been less than 5 youth in adult jails pre-trial in Colorado since 2012. There was very huge, very huge. And what's happening now is that this adult facility, the youthful offender system, transitioned itself. This was a place that had a high school, it had vocational programming, they had some athletics, they tried to make it seem like this isn't really a prison, this is a great place for young people. But as they saw that less and less children were going into the adult system, they refashioned themselves as a new young adult facility. And I was speaking to attorneys in Colorado last week just to talk about, what are you seeing today? And they told me that the high school now at YOS has been closed. So it is almost completely shut the doors to children going into the adult system. Now, it hasn't changed everything. There are still very significant work to be done around the prosecution of youth for sex offenses, who are still held to the same adult sentencing laws when they are charged as adults. There's still work to be done around life without parole. The Colorado Supreme Court has been fighting those decisions as well. And there's really work to be done to comprehensively reform our juvenile justice systems. We've had patchwork of reforms, but we haven't gone from A to Z and said, let's rewrite this code and make it completely developmentally appropriate across the board. There's also issues, which I think you're going to be discussing later on in the next 2 days, about kind of the boundaries of jurisdiction. And we've talked here about the boundaries between adult court and juvenile court. There's also the boundaries between the minimum age of jurisdiction, the maximum age of jurisdiction, and, as has been referred to, the child welfare system. So I now working to improve access to counsel for children in the child welfare system, and have learned a lot more about dual status youth who are in both the juvenile justice system and the child welfare system. Only 1 out of 4 children in the child welfare system do end up in the juvenile justice system, but when you look at the juvenile justice system, 2/3 of those children do have history in the child welfare system. And I was recently at an event where they said 80% of folks in adult prison have a child welfare history. So what is interesting about this is that these systems are siloed, not only in the way they operate, but in the way they look at children and in the way they perceive children. And I'll give you an example, is the state of Florida. Florida is one of the states that prosecutes the most children as an adult of any state in the country. There's no minimum age at which children could be prosecuted as an adult. You have to be 14 in order to qualify for direct file. I think they've prosecuted, I just read, 7,800 children as adults since 2011 for public safety. This is also a state that has a child welfare system, which is a much wider range of ages, birth to 17, that does not give children attorneys when they are in the child welfare system. So if you are a child in Florida and your parents or guardian have been accused of abuse or neglect, you are not appointed a lawyer to represent you. You are appointed a guardian ad litem who is a lay advocate volunteer. And that guardian ad litem role is to look at your life, look at your history, and make recommendations to the court as to what is in your best interest. In Florida, the guardian ad litem, like the child and the parent, is a party to the case. And the guardian ad litem gets a lawyer in Florida. So you have a system where the parent gets a lawyer, the social service agency gets a lawyer, the guardian ad litem who's deciding what's in the child's best interest gets a lawyer, but the child does not get a lawyer. And there was a recent hearing in Florida just in January. There was an attempt to amend the state constitution to allow for the right to counsel for children. And who was opposing it? Unfortunately, it was the guardian ad litems, who said it would be dangerous to give these children a lawyer that would advocate for what they want, because what they want is dangerous for them. So you have a state where you have simultaneous adultification and paternalism going on. A 14-year-old could be in handcuffs in one courtroom as an adult, but yet in another courtroom across the hall, they're too young to have the capacity to talk to an attorney. So we need to look at children across systems, look at children across the board, reduce the punitive measures, but also reduce the paternalistic measures and give all children more voice and more agency in the process. And I'm glad there's been discussion about the child welfare system here, because we do need to have a seat at the table. Child welfare advocates sometimes have been too focused on child protection and not so much on child well-being. But that's where the system is going now, is to look at child well-being and what is necessary for that child and also that child within that family. So I hope that there will be more discussion moving forward. There are a number of parallel initiatives. There's the movement to take all children out of detention facilities. On the child welfare side, there's a movement to get all children out of congregate care. And if we're not talking to each other, the children from the detention facilities might end up in the congregate care facilities that we're trying to get everybody out of. So I hope that there will be some discussion between our two systems moving forward so that we can ensure all children are treated like children and that all children can be kept safely at home with their families whenever possible.
Thank you. So I think that what you've just heard are two examples, particularly what Kim spoke about with respect to work in Colorado and what Michael talked about in terms of the reforms there in California. These are examples of where reform efforts have been successful and have changed the landscape. It's difficult to say whether or not this is exactly where the other 48 states and the District of Columbia will head in the near future, but what we can say is the kind of work that they described is at least laying a foundation for what other jurisdictions aim to be working on or are working on. The opening comment, I was obviously struck when Diane opened her remarks this morning about, and I appreciated Diane as a funder acknowledging the weak support right now from the philanthropic community for juvenile justice. That's just a fact. We're all grantees. We can speak from that perspective, but it's true. We've had great support in the past, but there has been a redirection to looking at the criminal justice system, including the most recent establishment of something called the Square One Project, which is to essentially start back at square one, and if we were to redesign the criminal justice system, what would that look like? And when I saw the announcement about that effort, I was both, wow, this is amazing, and then I said, so where's the support for doing this in the juvenile justice system? Because it really doesn't make sense to think about these as separate systems. And when I think about sort of the question, where do we go from here, where we have to go is to a more humane, a fairer, and a more rational system. And the degree to which punishment drives everything that we have historically done in our responses to criminal behavior in this country, the degree to which racism has historically driven everything that we do in response to criminal offending in this country, will continue to influence those decisions unless we get a square one as well for the youth justice system, where we can have the resources that are needed and the thinking that needs to come together to imagine a system that begins to look like the systems that are being created in California and Colorado, where you are, in fact, raising the floor of criminal responsibility for kids in the justice system, where you are substantially raising the floor for who goes into the adult criminal justice system, where you are changing the ways in which they get into the criminal justice system, where we are attentive to ensuring that families are engaged in this system, where we are attentive to ensuring that youth voice is heard. How insane is that you can have a system that allows for 14-year-olds, 13-year-olds, 12-year-olds to be prosecuted as adults and deny them the simple, obvious, inherent right to say something about what is about to happen to them in our court system, whether it's the justice system or the child welfare system. So when we look at this from our perspective as advocates, we can tell you all of the amazing things that have happened. We can tell you the horrible things that we are trying to build this progress on and come back from. But we also recognize that it requires, in a way, frankly, it requires you to tell the story about all of the ways in which the system continues to screw kids. I mean, we're here to talk about youth justice. So to be able to continue to tell the story about all of the ways in which our system continues to screw kids is incredibly important, because the reality is that we as advocates know that our strategies are weaker without a focus on media strategy, that our advocacy efforts will have less success if our efforts are not covered in the news, if you don't push that information out there. We all have our roles to play, and we are very mindful of the role, certainly, that journalists are playing in the world that we're living in today, and frankly have played in disassembling much of the stuff that happened in the 90s. I want to make sure that we have a good amount of time for questions. I just want to ask Michael to take just a couple of minutes. I think we're going till 11:05? 11:10. Okay, so just take a couple of minutes to talk about, I know, the issues about racism in our justice system, which, as I said, we can't talk about the system without acknowledging that, to talk about some of your advocacy around that.
Okay, thank you, Marsha. Yeah, I want to start off those comments by just making reference to an old friend of mine, Bart Lubau, who, from the Annie Casey Foundation, who often said we need to think about these systems and how they deal with young people and treat them as if they were our own kids. And what we see overwhelmingly in almost all of these juvenile justice systems is policies that are created by folks who are not thinking about how they would want their own kids treated. They're thinking about the other people's kids being treated in those systems. And that partially explains why there's such racial disparity in these systems, because often in the work I've done, I've seen and talked to law enforcement and probation officers, and basically they're explicit in saying these systems are not a place where white kids should be. And so that's part of how it's conceptualized and how it's framed. So I want to talk a little bit briefly about the disparities that exist within the juvenile justice system. So I'm sure, as you all know, there's not one national system. Each state has its own laws on what are crimes, what are the punishments. And so in essence, we have a state-by-state juvenile justice system. Each state has its own system, and D.C. as well. And so if we look at that in totality, there's some variation about it. We can see that in every state, at every stage of the juvenile justice process, there are racial disparities, meaning Latinx and African American youth are treated more harshly and get worse or more severe punishment or consequences at every step. So I'm just going to quickly walk you through. I know they said we're not supposed to go deep in the weeds, but I want to just give you these numbers so that you can have a sense of how profound those disparities are. So if we start off looking at nationwide, the African American, and I'm focusing on African American because that's where the disparities are the most stark. But it's also the case for Native youth and Latinx youth. So if you look at the African American youth population, that's 16% nationwide. And so you go to the next stage or the first stage of the juvenile justice system, arrest. And you look at arrest, African Americans are 34% of those who are arrested and brought to the juvenile justice system. So right off the bat, there's a doubling compared to their representation in the juvenile or youth population. The next stage, and keep in mind, part of why that happens is law enforcement officers have a great deal of discretion about who they arrest and who they don't arrest. And so the decision whether to take a kid home or to take him to lockup is really all in the hands of that law enforcement officer. And we should also point out that one of the biggest drivers for increasing arrests since the 90s has been school-based arrests. And that's due to the fact that there's been increasing deployment of law enforcement on school campuses. And as that number of police on campus has gone up, the number of arrests of students has gone up. And so looking at the next stage, which is whether or not there's a petition filed, basically that means the prosecutor makes a choice whether to go forward with this case or to drop it or divert it. And we see there as well, there's tremendous disparity. So African American youth are 39% of those petitioned, that is, those whose cases are formally filed in juvenile court, even though, again, 16% of the youth population. And then who's detained, so one of the crucial decisions in this process, because it has serious ramifications for the outcome, is whether or not you're going to have to stay locked up while your case is processed through the system, or you get to go home and come to your hearings as a free person. So that is called being detained. Of those detained, African Americans were 47% compared to, again, 16% of the youth population. I'm sorry, 42%. My eyes are not good. Sorry about that. And then adjudicated. So there's a number of things that can happen between when the case is filed, petitioned, and when it actually gets to the point of trial, which is in the juvenile system called adjudication. There could be motions to dismiss, motions to exclude evidence, deals, pleas, a number of different things. And so as you go deeper and deeper into the system, African American youth represent more and more of those still involved in going deeper. So of those adjudicated, African Americans are 36%. So hopefully in Q&A we can talk a little bit about implicit bias and how that affects judges and their decision making. But there's a great deal of work that's been done on that, and I can talk about that. And then finally, the last two, waiver, which is, again, when a person's case, a young person's case, is initiated in the juvenile court system, but is transferred to the adult system. So now we're talking about people who are possibly subjected to very serious consequences in terms of not being under the jurisdiction of the juvenile court until they reach majority. They could have 10, 15, 20, 30, 40, 50-year sentences if they're in the adult system. So waiver, or those young people processed in the adult system, 44%. And then finally, those who go to prison, 58%. So those are those young people who have gone to adult court, are processed there, tried, and given a sentence. And remember, there are a number of sentences that can be the outcome of being found guilty in adult court. You can be on probation, you can be ordered to pay a fine. So when you go to prison, that's the deep end of those sentence range, that sentence range. So you're talking about someone who's going to be locked up for a significant period of time. And so for young people, 58% African American compared to 16% of those in the youth population.
Thank you. Okay, Q&A. Questions? Wait for you to pass the microphone around.
Okay, ladies and gentlemen, we have left a lot of time for Q&A, so we're very keen to have your questions. Who's up?
Please say your name and stand up. I'm Christian Jaime with the Bay Times. In terms, referring to the ad litem situation in Florida, how is that not a violation of the precedent set by Gideon v. Wainwright? And has that law ever been challenged to any Supreme Court, whether state or otherwise, to establish that precedent has already been set?
Excellent question. So, children who are in the child welfare system do not have a right to counsel under the United States Supreme Court. The United States Supreme Court decided in Gideon that adults have the right to counsel, decided in re Galt that children in the delinquency system have a right to counsel, but there has been no Supreme Court decision deciding children in the child welfare system have a right to counsel. Currently, federal law, which is called CAPTA, the Child Abuse Prevention and Treatment Act, provides that states must give a child either an attorney or a volunteer guardian ad litem. That is also that is a very ripe issue that is up for debate right now in D.C. The National Association of Counsel for Children is trying to require that every child be appointed an attorney, and then they can also have a lay advocate as well. So there is no. There has been one federal district court decision in Georgia, Kenny A., that did decide that per Georgia's state constitution, children have the right to counsel because of their liberty interest. These are children who are removed from their homes, removed from their schools, placed in facilities, placed in foster care, and due to that and due to their due process rights, they have a right to counsel. But we're trying to expand that across the country.
Hi, I'm Cassie Feldman from The Appeal. Michael, you mentioned school-based arrests, and I was just wondering, in the wake of Parkland, where we've seen sort of like a focus again on school resource officers, are we seeing an increase in arrests? Is anyone tracking that, or is it too soon?
I would say it's too soon. I mean, I think it's a really important point, though, because many of the politicians in Washington, D.C. Are absolutely just opposed to talking about gun control. And so as a result of that, the conversation always shifts to how do we protect these kids? Let's put more cops in the schools, which has been shown not to be effective and actually counterproductive. But because we can't really get to a real solution for the problem, we are always diverted away. And there is research that shows that the more cops are on schools, the higher the rate of arrest for students. And that's a trend that goes back several years. So I have no doubt that that trend will continue.
Yeah, I would just very quickly add to that there are some really innovative programs. One that actually was started several years ago in Georgia by Judge Teskey in Fulton County, now being picked up in Philadelphia actually by a former 30-year veteran law enforcement officer who left the police force to develop a diversion program. And these programs are essentially working with school systems as well as with juvenile courts to divert kids from the juvenile justice system if there are school-based offenses to deal with those within the community, within families, and with local resources. Those, I think, again, when we think about where are we going, what's coming in terms of the juvenile justice system going forward, I think there is traction to try to replicate those programs because what they have done is essentially to drastically cut. You heard the cuts in transfer numbers as you change statutes. They have drastically cut the interaction between kids in schools and the justice system, and that makes a big difference.
Hi, Tessa Duval with the Florida Times-Union in Jacksonville, Florida. First, to add to another maddening thing I learned about Florida is, not only can you be charged as an adult as a kid. So I know of this 13-year-old who's arrested for first-degree murder. He's been in prison since then. He's 17 now, and because of the, quote, disability of underage, he cannot consent to an interview with me. So that's another maddening thing about Florida. But I wanted to ask about direct file specifically. Like, Florida's, again, a state where the prosecutor and the prosecutor alone can decide if a kid is direct filed. So what have you seen in states that have been able to move past that, who have passed some kind of reform? Because in Florida, the prosecutors just oppose it every year and it goes nowhere. Like it always comes up and then it dies a painful death in the legislature. So what do you see in common with the states that have been able to get some kind of reform in regards to direct file?
Well, I'll just say quickly with respect to Florida, there is some litigation that is underway that we are hoping to expand to challenge direct file in Florida, to really challenge that unfettered authority of prosecutors to make these kinds of decisions. It's not unique to Florida, but it is particularly venal in Florida in its implementation.
We've had 2 years of since the end of direct file in California, so we have seen some evidence of what the change to the future looks like. And So the first thing of note is that the number of young people who are tried in adult court has gone down dramatically. And looking at the data, it has turned out that young people were being direct filed on for relatively lightweight crimes. And in California, there was a list of 30 eligible crimes, so prosecutors basically for reasons totally unrelated to the seriousness of a crime were direct filing. One reason that we've learned about is this was a way to leverage either a particular person, if a group of people were charged with a crime, to leverage one of them against the others to force one to either plead out or to testify against the others. And so this was all like leverage. It had nothing to do with how it was sold to the people, which was, these were really heinous criminals, unrepentant, blah, 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 blah. Nothing like that at all was what was really happening. So as a result, there's been a reduction in young people, and I'll just put it out there, I don't think any young person should be prosecuted in adult court. All the evidence shows it's really harmful and counterproductive. But it has not had any kind of negative effect and only positive effects in California.
I just want to add something about the campaign. We had the same experience in Colorado where year after year we were coming up against prosecutors who had considerable political influence over the state legislature, and we're really the only voice on criminal and juvenile justice at the state legislature. Over time, the juvenile defense community became experts and became go-to people, but what really changed the game for us was having the support of the MacArthur Foundation and the national campaign to reform state juvenile justice systems, and the alliances that were built with conservative-leaning organizations like Right on Crime, other groups like that, as well as faith-based groups. And we were able to reframe direct file to, this is about government power. This is a government lawyer who's making a decision about your child that your family has no say in. Because once you're prosecuted as an adult, the parent is out of the picture, unlike in juvenile court where the parent is still hopefully sitting at the table and participating in the case. So there was a kind of limited government family values frame around this that I think really helped turn the tide. And we happen to have a lot of libertarians in Colorado, and they were, very receptive to that argument.
Just very briefly, I'm sorry. That's something that you all should be aware of, and that is that there are these conservative groups who are very engaged on juvenile justice reform, adult side criminal justice reform as well. A lot of it comes from their desire to cut budgets, and the spending that's required for incarcerating people is off the charts. But it's something interesting that these groups that for so long pushed the punitive approach have reversed course and are now actually partnering with advocates to try and undo some of the mass incarceration infrastructure.
Hi, Jonah Newman from the Chicago Reporter. Michael, I wanted to clarify something you said earlier. You said school-based arrests were driving a rise in youth arrests. Is the rise in juvenile arrests a trend across the country? My sense in Chicago is that arrests of juveniles has actually been going down pretty steadily. And then where would you go to find that data on a national or local level?
Yes, you're right. So I was referring to the 90s when it was still going up. But you're right. Overall arrests are going down. In terms of school stuff, the Department of Education has data from every school district in the country. Their Office for Civil Rights has a data collection, but they are not very good about data on arrests. And so it's really difficult to pin that down. We've tried to get a handle on that a few times, and so they are responsible. Well, they are doing national data collection on what happens at schools, but they're not good about arrests because often it's other entities, police who are called for particular incidents, or they contract with the local police department, and that police department keeps their data for themselves and is not part of the school data system. So it's hard to track that.
Is there any good data on juvenile arrests overall, not just school-based arrests?
From DOJ. Yes, the Department of Justice tracks that data. It is much better now in the sense that in the 90s, we didn't necessarily know in 1996 what had happened in 1994. The data is a bit more in real time now, so easier to know what's happening.
Hey, my name is Ko, and I'm in Jackson, Mississippi, and I write for an alt weekly there. I know, Mr. Harris, you were talking about that kids shouldn't go into the adult system ever, but I would love for you guys to kind of touch more on discretion, because the police have a role in it, judges have a role in it, if kids get in trouble at prison, then that has a factor in it. So there's a lot of levels of discretion. So I'm wondering if you can kind of tease out who should have a say. Should it be a youth court judge that kind of decides whether you go into the adult system if you believe in the adult system? I'd love to hear your thoughts.
So that's a great question, and I think maybe we'll each take a minute to give you our reflections. Discretion is both a benefit and a curse. When we were getting rid of the death penalty in this country, in part back in the 1970s for adults, it was initially struck because it was considered to be too arbitrary, because discretion was exercised in an arbitrary fashion. The response from some states was to make it a mandatory penalty, and the Supreme Court said, well, wait, we can't do that because we can't eliminate the potential for individualized consideration. And that concern is what drove, of course, the court in eliminating mandatory life without parole. So there is we place a high priority on discretion. The problem is that wherever that discretion is exercised, whether it's at the law enforcement at the front end, at the arrest level, whether it is at the charging level by prosecutors, by the adjudication determination, by judges, or even by agency administrative officials within the executive branch who in many states have the ultimate determination about when a child is released from the juvenile justice system of supervision. We are dealing with humans. We are dealing with people who exercise their discretion often in flawed and failed ways. And I think most prominent within that realm of concern is a concern about, frankly, not just implicit bias, but explicit bias. There is lots of research that not only talks about the ways in which bias infects decision-making, the ways in which simply how we perceive youth of color affects how we process information that is being said about them, the unwillingness to send them back into communities that we have an unfavorable opinion of. So from my perspective, doing this work for a long time, it would never be about getting rid of discretion, because the alternative is kind of unacceptable unless it's a bar. I mean, we're very happy with absolute bars on things, but to require that certain kinds of action be taken inevitably will hurt kids. So it is trying to figure out a way to engage in guided and thoughtful and rational and fair discretion. That's a challenge, and I think, again, maybe each of us has some perspective on that.
I think the discretion has to be tempered and balanced by due process. So if the prosecutor has discretion to file a motion to transfer a case into the adult system, then the child, the defense, needs to have notice of that motion. They need to have an opportunity to prepare for that hearing. They need to be able to call an expert to that hearing, and they need to be able to present evidence, hopefully based on articulated factors in statutes that can then be reviewed by another judge or by an appellate court. And this is actually one of the current challenges in Colorado, is now that the direct file cases are so narrow in scope, age is always going to be high because it's only 16 and 17. The seriousness of the offense is always going to be high because that's what the offenses are now limited to, but yet those are still factors to be considered by the judge. And so they're now taking another look at what should the factors be, because all of the good factors about pattern of living, trauma history, adolescent development are all kind of packaged into one. So you need a statute that's fairly articulated, that people can provide evidence on, and that can be reviewed.
Okay, so we have time for 2 more questions and quick answers. Yes,
Sure. Hi, I'm Grace Toohey. I'm a reporter in Baton Rouge, Louisiana. You talked about the win that you had in Colorado keeping children out of adult prisons, but then when you went back to the juvenile prisons that they were transferred into, how the whole theory of rehabilitative settings had kind of changed. Where in Louisiana, there's going to be a similar law that goes into effect, and I'm interested in seeing, what do you think there should be to look at these settings that the juveniles are being moved into? Who is monitoring to make sure that they are actually being implemented in the way that the law wanted them to be, so it's not a one step forward, two step backwards kind of thing? Are there groups, organizations, advocates? What is a good process to look at that?
So I'm going to punt that question because I know there's a panel later this afternoon that is going to specifically talk about institutional issues, and I think we'll probably get to many of the questions that you just asked. Okay, but Kim's going to clarify one.
Sorry, I just want to clarify. The facility that changed was a facility in the adult correction system. So there was a special facility in the adult correction system that is now changed to young adults. It was not a juvenile corrections facility.
Hi, my name is Lincoln Blades. I'm from Teen Vogue. I had a question for Kim and a question for Michael. Question for Kim. When Colorado switched to a more punitive youth model, how did that affect, or what effect did that have on young girls in the criminal justice system? And also I want to know if you had statistics, the same ones you had about African American youth, do you have those specifically for African American girls?
Well, girls have definitely been direct filed in the Colorado system. They are not as prevalent, and they were not as big of a picture in the media and in other areas. It was very much focused on black young men in terms of coverage, and that's what the statistics bear out. I think girls are under 10% of the direct file population in Colorado.
I would direct you to two places. Monique Morris published a book on black girls in the school-to-prison pipeline that has some excellent data. And the second place I will refer you is Georgetown recently did a report on girls in the system. And so that also has some excellent data as well.
Okay, really quick, one last question. Something that really bugs you that reporters do that you want to say to them, please don't do that.
Give me a kid who will tell me their whole life story and go on TV and go on record, and that's asking a lot of a kid. And I hope that there can be a way. There certainly are people who are willing to do that and come forward, but I hope there's ways to tell the story without doing that.
Yeah, ditto on that. Kids often can't come forward. The point I would say is take the time to educate yourselves. I think that we as lawyers all read articles all the time that your colleagues may have written, and we read a couple sentences and we say, wow, they got that wrong. It's not that complicated, but there are nuances and there are words that we use to talk about the systems that we work in. And I think it may just take an extra 5 minutes on that phone call to make sure that you understand what we're talking about and what part of the system we're talking about.
Yeah, I agree with both of those. My pet peeve is the not understanding that for young people, a lot is jeopardized by them going public. And so a lot of times when we file our cases, we are taking steps to try and conceal their identity. And so fundamentally, we're not trying to expose them to the public. So I think that's something that reporters don't really grasp, is that, and I get that you want a compelling human being to be like the anchor for your story. I get that. I understand what that's about. But for us, in our cases, a lot of the work we're trying to do is prevent retaliation and keep the names of these young people from getting out into the public. So it's a difficult balancing act in many situations.
Okay, thank you.